This Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Supreme Court Clerk Jim Hibner and the AOC staff and your staff as well, Jim, for helping us put these oral arguments on by Zoom and then helping us broadcasting them on YouTube. This is the call. Welcome to those that are viewing and those that are present. We are conducting the afternoon session of the February docket here in Nashville, Tennessee. Mr. Clerk, if you don't mind, call the case, and then I'll inform the participants how we will proceed.
State of Tennessee versus Desiree Petty.
I'd like to introduce the panel of the court today. From Kingsport, Tennessee, Judge Robert Montgomery. From Nashville, Tennessee, Judge Robert Wiedemeyer, and I'm John Everett Williams from Huntington, Tennessee. These types of cases being Zoomed are done exactly like you would do them in person. Each side is awarded 20 minutes, and the appellant may reserve time for rebuttal if they will do so upon introducing themselves to the court. I will try to help you keep track of your time. With that, delighted for you to be here today, and the appellant may start and introduce himself, and your time starts now. Thank you.
Thank you, Judge. My name is Donovan Vosick, attorney in Lebanon, Tennessee, and I represent Ms. Desiree Petty. And if I may, reserve 10 minutes for rebuttal time. Okay, thank you. After a review of my brief and the state's brief, it appears we've actually agreed on one particular issue, but our differences center around issue 2 on whether or not the trial court erred in abusing its discretion in extending the probation sentence in order to aid in the collection of a judgment for restitution.
Wouldn't you have to appeal that when it happened?
Fair question, yes. And I think that would have been a time, but whenever it was extended again, I believe it brought up the new issue of whether or not her probation was extended for the purpose of aiding in the collection of that judgment as well.
Well, when he revoked the probation, didn't he pretty much do away with that?
Do away with?
The ordering of the restitution amount.
No, sir. He increased.
Incarcerated?
No, sir. She was to serve 90 days. And so she's completed that, but he increased the order of restitution from $150 per month to $200 per month and ordered that she forfeit any of her federal tax return to the remaining amount of restitution. And it's one of the issues that kind of goes into it as well, in that your federal income tax is an indefinite amount. We never know how much we're going to get, if we get anything at all. Does that answer your question from my perspective, Judge?
I believe so. Yes, sir.
Thank you. And the state, I guess, distinguishes the case that I primarily rely on, which is State v. Irk. And in Irk, the trial judge had ordered the defendant to serve 6 years. Then once he comes out of prison, to serve 24 years on probation, and that the restitution would be whatever is ordered as part of the personal injury judgment that was still pending at the time. And the state specifically states that there's no evidence in the record that the defendant is subject to a civil judgment owed to the victims. And I agree, that is true. It is true in this case, and it is likewise true in Irk. Neither parties was subject to a civil judgment at the time of the ordering of restitution, or even in the opinion in Irk, they still wasn't subject to the additional civil judgment. The civil case was pending according to a head note or a footnote in that case. So, and to the extent there's not a future civil judgment, I really believe there is, in that TCA 4035-304H allows victims to convert a restitution award to civil judgment. So just like in that case of Irk, that there was a potential civil judgment coming down from the personal injury case, once this probation expires, the alleged or the victims have the ability to convert this to a civil judgment as well. And I think in Irk, the court really focused on what was the trial court's intentions in sentencing Irk to that 24 years of probation on top of that 6 years. And the same intent can be adduced from the opinions or commentary of the trial court here in this case in Desiree Petty. And, I've kind of gone back and looked at some of the different comments, and they were all centered around repayment or restitution, not the drug usage. And it was initiated, and kind of going through it, the trial court stated the current rate of pay, and it would take 29 years to repay. And the trial court made an inference that she earned more than she reported. Then the trial court opined that Ms. Petty purchased marijuana with the funds, and if she had enough to do that, she had enough to pay restitution. And then one of his last comments, where I think is important, of kind of a walkaway, is the trial court said, "Let's get it paid, okay?" And so all of his comments focused on the monetary amount of getting the restitution repaid, not, the drug usage in which Ms. Petty agreed that she violated terms of her probation. And so the extension, which was actually initiated by the probation officer, not the trial court, was, I think, frankly, to extend it to allow her more time to collect that restitution order. And that's why I believe all those comments by the trial court converge back to the central focus point, which is money. There wasn't an inquiry about the drug screens or rehabilitation options. It was all centered around getting it paid. And then lastly, the states conceded that we didn't have the opportunity to have a full hearing and erred in modifying the terms of the restitution. I don't want to muddy the water on that, but I'm happy to answer any questions that the trial court or this court may have.
Are you saying, maybe I got this one mixed up with one earlier this morning, but did this trial judge increase the term or the length of her probation in this revocation hearing?
Yes, sir. He extended.
How long?
1 year.
1 year.
Yes, sir.
So every time that she violates the probation orders, he is giving her a sentence and then additional time?
Yes, sir.
So shock incarceration's not working, the 90 days. And so she's going to be on probation now for 15 years. Is that correct?
Yes, sir.
I don't know how we can help you any on the violation of the probation, because there were 3 allegations of violations, any one of which, if she did, the judge was well within the right to sentence to 90 days and extend, based on what my reading of the statute allows. It's one of the first remedies that you can do. I mean, I don't think you could probably have a good cause if he said you have to go back to jail for the full 14 years. And the state is conceding, at least, that you need a hearing on her ability to pay, based upon the newest. So what else is there for us to do for you, if we could?
But I guess my issue is the extension. Now, if they've conceded to that point, I agree with you, Judge, that the trial court can extend up to 2 years, even though she'd already been extended once for 2 years. But I don't believe the trial court can extend for the sole purpose of providing more time for the collection of this restitution judgment. And I think that's what the entire extension was about. It wasn't related to the violation based off smoking marijuana. It was solely based off having more jurisdiction or more time of jurisdiction to collect in this award of restitution.
Okay. Anything further?
No, sir. I'll defer to the state and reserve the rest of the time. Thank you.
What say the state?
Good afternoon, Your Honor. Good to see y'all again. Austin Watkins appearing on behalf of the state of Tennessee. And the state's position in this case is that the trial court partially revoked Ms. Petty's probation and properly extended the probationary period by 1 year. It did, however, err by failing to have enough adequate proof, make factual findings about her ability to pay and her financial condition when it modified the terms of her restitution payments. And so I'm happy to speak about anything that's particularly important to the court, but I think just to respond specifically to the idea of the extension here, whether it was proper, Your Honor, it's pretty clear the statute gives the judge the authority to extend the period for up to 2 years, and it doesn't really matter why the court does that. It's kind of a benefit to the defendant that the entire probation is not being revoked, and it's generally important when you're getting towards the end of a long probationary period, such as in this case. That's kind of an extra means of going, look, it might be a little harsh to revoke the entire thing since you've done so much time and then make a probationer, serve the sentence. Allowing for that extra extension is, kind of a nice means for there to be some punishment for the violation, but it doesn't mean there has to be, a full revocation. And so here, even though the trial judge kind of sua sponte went into restitution and made it clear that the court felt that she should be paying more money, the record doesn't show that the court was specifically extending the probation for that purpose of paying more restitution. And she had already violated probation once before, and the trial court had extended it up to 2 years at that point. So this was, a second violation, and I think the court had the authority to do that, and it didn't abuse its discretion by tacking on an extra year when she was getting towards the end of it. And with regards to the IRIC case, a couple of things about that. Yes, in IRIC, the civil litigation was pending, but the problem was that it was like a 24-year probationary period. It was really long, and the court had already directly tied the amount of restitution to whatever the civil judgment would be in the future. So we knew that, from the few facts on that opinion, it seemed that the court was trying to, determine the amount and the duration of probation, and using it kind of as an enforcement arm for the civil judgment. Well, again, the fact that, there's not any future litigation pending that she's potentially going to be subject to a judgment. And as, appellant's counsel acknowledged, after the IRIC case, the statute was amended to allow a probationer's outstanding restitution to be converted to a civil judgment. So there's really not really any need for the trial court to extend probation to try to collect on a certain amount when whatever's left can be converted one way or the other. I don't think there's the same incentives for what was kind of happening in IRIC to still be at play today under the current statutory scheme. And so, based on the evidence and under an abuse of discretion standard, the trial court had plenty of, reason to extend it by 1 year toward the end of this long probationary period. And so the state does concede that the modification of the terms of the restitution, if I remember correctly from the transcript, there was Ms. Petty's general manager was present at the hearing and available, presumably to at least talk somewhat about her, or at least her income, if not some of her other broader financial conditions. And the trial court, didn't hear from that witness, and there just was no proof in the record other than that she was employed. The trial court didn't have any proof, at least in the record that we've got, about how much she was making, how much she could pay, what her other obligations might be. And so this case law is pretty clear that is an improper basis to set a restitution amount without adequate proof to do that. So state agrees that a remand for further evidentiary hearing on that issue is proper. But there hasn't been any really question. She admitted one of the grounds for in the violation of probation warrant, and so that gives that automatically then gives the trial court the ability to do whatever it wants to do. And what it did here was do 90 days plus an additional year, and it did modify the restitution payments. That's okay. That's the state's position. So any specific questions that I can help the court with on this one?
Judges?
Okay. All right. Well, we would ask you to remand for that further hearing, but we do ask you to affirm the partial revocation and in particular the extension by 1 year of the period. Thank you, Your Honors.
Thank you. Appellant, you have some rebuttal time. Please keep it to rebuttal.
Yes, Judge, I really don't have anything else to say. I believe we're pretty short and concise on this appeal. And
When I've had the fortunate opportunity to tell people earlier today, when cases are submitted that are lawyers are prepared, they can be brief and they can be effective and they can be very much appreciated by this court. And with that, we'll thank both of you for a good job. Well done. And we will stand in recess till 2 o'clock.
This honorable
Thank
court
you.
is now in recess until 2 p.m.